morning, ladies and gentlemen, distinguished delegates, dear colleagues. I hope you have enjoyed your staying here in Tehran so far. And in this morning, as you all look like you are all fresh and radiant and active for the participation in this special meeting on violence and extremism. We are having a half a day meeting on violent extremism and terrorism. As far as the legal aspect of this issue is concerned. For this special session, we have a number of friends, distinguished friends, dignitaries who are specialized on these topics. Before going into more details and to avoid any wasting time, I would like to give the floor to the Deputy Secretary General of ALCO, Ms. Harimoto, for the introduction of the topics. You have the floor, Madam.
Thank you, Mr. President, and good morning to everyone. Distinguished delegates, ladies and gentlemen, the issue relating to international terrorism was introduced as an agenda in 2001 at the behest of the Republic of India. It was felt that consideration of this item at ALCO would be useful and relevant in the context of the ongoing negotiations in the Ad Hoc Committee of the United Nations on elaboration of the Comprehensive Convention on International Terrorism. The successive sessions directed the ALC Secretariat to monitor and report on the progress at the Ad Hoc Committee and requested the Secretariat to carry on an in-depth study on these topics. The Center for Research and Training brought out a preliminary study on the concept of international terrorism in the year 2006. In accordance with the mandate received from the member states, the Secretariat report prepared for the 53rd annual session, document ALC/53 Tehran /2014/SD/S7, has reported on developments in the Ad Hoc Committee on International Terrorism and on the Counterterrorism Committee. Deliberations on the Comprehensive Convention on International Terrorism at the 6th Committee, as well as the 68th session of the United Nations General Assembly. Comments and the observations of the ALC Secretariat, and a draft resolution on this topic. I'm pleased to welcome Dr. Rohan Pereira, Chairman of the Ad Hoc Committee, to brief us today. However, the subject for today's half-day special meeting has expanded the scope of the Secretariat study, and it's now entitled Violent Extremism and Terrorism. This topic has been proposed for the discussion by the host government, that is the Islamic Republic of Iran, and a draft resolution has been placed on the table for your considerations. The topic gained prominence since the adoption of the United Nations General Assembly Resolution A/RES/68/127, February 20th, 2014, entitled A World Against Violence and Violent Extremism. In that resolution, the General Assembly was alarmed by the act of intolerance, violent extremism, violence, including sectarian violence, and terrorism in various parts of the world, which claimed innocent lives, caused destruction, and displaced people, and rejected the use of violence regardless of any motivation. Recently, perturbed by the ongoing incidents of violence, the Security Council on August 14, 2014, unanimously adopted Resolution 2170, condemning gross widespread abuse of human rights by extremist groups in Iraq and Syria. Violent extremism not only poses a real threat to the life of the innocent civilians, but also seriously endangers peace and security of states, regions, and the world. Increasingly sophisticated use of the internet, social media, and information technology by violent extremists added an additional layer of complexity to this issue. The multifaceted scourge of violent extremism has become so pandemic for the past couple of years that an increasing number of ALCO member states have been hard hit by its diverse manifestations. The brutality exhibited by violent extremist groups in the name of their faith and belief is alarmingly unprecedented and presents a serious threat. The questions that we need to address in this morning are how international law deals with violent extremism and terrorism. As these are very complex problems impinging upon the internal and external security of states, criminal law at the national and international level has to be strengthened. In addition, it is also equally necessary to appropriately apply the principle of international humanitarian law and human rights law to such situations. Before I end my brief introduction, I would like to once again thank the host government for this timely initiative. A special thanks goes to our expert panelist, Dr. Nersin Mosafa, professor of Tehran University, and Mr. Qader El-Tali, advisor for the Islamic World Affairs ICRC, for sparing their valuable time to share their views on this important topic with us. The draft agenda for the meeting has been placed before all of you. Thank you very much, Mr. President.
I thank the Deputy Secretary General, Ms. Harimoto, for her introductory remarks. And now we are having the privilege of having with us Dr. Prera, Chairman of the UN Ad Hoc Committee on Measures to Eliminate International Terrorism and a former member of the ILC. You have the floor, sir.
Thank you. Thank you very much, Mr. President, distinguished delegates, distinguished panelists. First of all, I must thank the ALCO for this opportunity to provided to me this morning to address in my capacity as chair of the UN Ad Hoc Committee on Measures to Eliminate International Terrorism. The work that has been accomplished within that committee since its establishment in 1997, and also to draw the possible linkages between measures being taken to combat terrorism, to provide a normative or legal framework, and possible impact that could have on this new issue of extremism and violence. So it's my intention to provide this morning a broad overview of this contribution in providing that legal framework to enhance international cooperation, and through that a basis for a legal response to this phenomenon. The identification of the acquis, or the overall architecture of the existing what are called the sectoral conventions dealing with specific aspects of the phenomenon of terrorism, could serve to highlight the building blocks that exist already on which a possible legal response to violence and extremism could be formulated. Acts of violent extremism, as in the case of terrorism, involve the indiscriminate use of violence against innocent civilians. As stated in the General Assembly Resolution 68/127, I quote, entitled "A World Against Violence and Violent Extremism," it involves, and I quote, "the targeting of civilian population, including women and children, in violation of international law, in particular human rights and humanitarian law." On these aspects, I'm sure we shall hear from the other panelists, so I shall not go into too much detail, but let me make the point that from international criminal law perspective, violent extremism would involve a range of crimes categorized as grave crimes under international law, including the bombing of public buildings and infrastructure facilities, hostage taking, arbitrary executions, and so on. So these are the possible points of convergence and shared characteristics of acts of violence and extremism and acts of terrorism. It is against this background that the existing legal regime relating to combating of international terrorism must be examined. I will first give a broad overview of the principal features, as I said, the broad architecture of the sectoral conventions, which of course begins from the early anti-hijacking conventions, hostage taking, to the more recent, what are called the new generation conventions formulated within the ad hoc committee since 1996, Convention Against Terrorist Bombings, Convention on the Suppression of Financing of Terrorism, and Nuclear Terrorism. Before I conclude, I'll say a few words on the draft Comprehensive Convention on International Terrorism, which is still before the ad hoc committee, the negotiations on which will resume in October next month. Basically, the sectoral conventions against terrorism rest on the extradite or prosecute regime, intended to ensure that there would be no impunity for those offenders who commit what are called specific crimes as defined in those sectoral conventions. It's premised on the principle that an offender who commits any of these convention crimes will find no safe haven in the territory of any member state. And it imposes a clear obligation on a state to either extradite an offender to a state seeking his extradition, or for some reason, if it does not want to extradite, there is an obligation to submit the case for prosecution without exception whatsoever. Essentially, the rationale for that regime is to preclude any impunity in respect of this category of offenders who are charged with committing crimes of a grave nature under international law. The extradite or prosecute regime is supported by what I would call supportive pillars, which would enhance the effectiveness of the extradite or prosecute regime. Firstly, the obligation on states to criminalize the convention offenses under their domestic law, to categorize them as serious crimes under domestic law, which carries appropriate penalties which take into account the grave nature of these offenses. Secondly, the extradite or prosecute regime would require states parties to confer on their domestic courts, extraterritorial jurisdiction, so that in the event of prosecution instead of extradition, the domestic courts would have jurisdiction to exercise, to entertain a prosecution irrespective of where an offense has been committed. Thirdly, there are a number of provisions in these conventions to facilitate extradition procedures, that a request for extradition does not, to ensure that a request for extradition does not fail on a mere technicality. The clear example, for want of a bilateral treaty, generally it is recognized that extradition is dependent on the existence of a bilateral extradition treaty. Now, the conventions provide that in the event of there not being a bilateral treaty, the parties could at their discretion treat these conventions as the legal basis for extradition. And they also require that the convention offenses be deemed extraditable offenses under their respective domestic laws. And there are a number of provisions to facilitate mutual legal assistance by way of exchange of information, evidence, and so on. So these are all the supportive pillars that exist in the sectoral conventions in order to ensure that extradite or prosecute regime is an effective regime. So these features clearly underline the obligation of states to cooperate in the prevention as well as the investigation and prosecution of terrorist crimes. And in my view, they do provide clear signposts in any legal response that could be formulated in dealing with this phenomenon of violence and extremism. A word about what I refer to as the new generation conventions, which we in the ad hoc committee have been able to adopt within the last 10 years or so. The Terrorist Bombings Convention, Terrorist Financing Convention, Nuclear Terrorism Convention, which contains certain features which marks a departure from the legal regime that existed with regard to what I would call the first generation conventions. Firstly, there is an injection of an express reference to a terrorist purpose or intent, which was lacking in some of the earlier conventions. Example, they refer to causing of death or serious bodily injury to any person or serious damage to property. Quote, when the purpose of the conduct by its nature or context is to intimidate a population or to compel a government or an international organization to do or abstain from doing any act, unquote. This is the element of what sometimes is referred to as agitational terror, which distinguishes this category of terrorist crimes from common crimes. Secondly, these new generation conventions treat the offenses of terrorist bombings, financing, and nuclear terrorism as non-political offenses for purposes of extradition or rendering mutual legal assistance. This is again a new provision which is not found in the early anti-terrorism conventions. Extradition laws of many states provide for an exception that if an offense is committed in furtherance of a political motive or a political objective, that could preclude extradition. In other words, the offender can plead that he committed a certain crime in furtherance of a political motive of the attainment of a political objective. There's a particular historical background to that exception. What these conventions do is to take away that defense, that you committed a horrendous, a grievous terrorist act involving the indiscriminate use of violence against civilians in furtherance of a political objective. It is not possible to plead that defense in terms of these new conventions, given the horrendous nature or the heinous nature of these crimes. That's a major departure from existing. And then, of course, thirdly, there are enhanced measures of mutual legal assistance going into much more detail than the previous conventions. For example, Terrorist Bombings Convention contains many provisions by way of exchanging information, intelligence on prevention, in cooperation among states parties, in post-blast investigations, technical cooperation. And of course, the Terrorist Financing Convention contains very, very specific and detailed provision. Cooperation among financial institutions and banks in sharing financial intelligence, take into account the fact that trans-frontier flow of funds to terrorist coffers cannot be done by a single state unless the central banks, the financial intelligence units of each country, through money laundering legislation and so on, devise a system of rapid exchange of financial intelligence with regard to trans-frontier flow of funds. So these are new elements which have emerged through the new generation conventions which have been produced by the ad hoc committee. The underlying rationale of the legal regime of the sectoral conventions is that, and this is repeated in annual resolutions of General Assembly on measures to eliminate international terrorism, the most recent being Resolution 68119 of 18th December 2013, that a legal response to terrorism must be in conformity with international law. In particular, human rights, international humanitarian law, and refugee law, and that measures of cooperation must be carried out in conformity with principles of respect for sovereignty and territorial integrity of states. Now, having given that broad overview of existing conventions in this field and their principal elements, let me say a word about the draft Comprehensive Convention on International Terrorism, pending since the year 2000 before the ad hoc committee. The mandate of the ad hoc committee is contained in General Assembly Resolution 59/290, through which the General Assembly called upon the ad hoc committee, while working at that time, working on the Nuclear Terrorism Convention, it also requested the ad hoc committee to address, and I quote, means of further developing a comprehensive legal framework of conventions dealing with international terrorism, unquote. Consequent to that mandate, the ad hoc committee had before it a draft of a comprehensive convention on international terrorism presented by the Government of India, a founding member state of ALCO, and the negotiations commenced in 2000. Along with that mandate, there was also a proposal by the Government of Egypt for the convening of a high-level conference on international terrorism to examine all aspects of all forms and manifestations of international terrorism. And these two issues have been receiving the attention of the ad hoc committee. Now, the principal objective of this exercise is for the identification of possible gaps in the existing sectoral regime, sometimes referred to as a piecemeal approach to terrorism. A piecemeal approach to terrorism. And in the course of that, the identification of these gaps, the draft CCIT provides for coverage of offenses such as those directed against the environment, a credible threat to commit a terrorist crime, and so on. And the Comprehensive Convention also envisages enhanced measures of cooperation, not only mutual assistance, but also clear obligations on states not to permit their territory to be used for the preparation for the commission of terrorist acts against other states, not to permit terrorist installations, training camps, and so on for activities directed against another state. This, of course, is obligation under general international law contained in the UN Declaration on Principles of International Law on Friendly Relations and Cooperation among States, Resolution 2625 of 1970. So the basic regime here too is the extradite or prosecute regime, and in that process is a process of trying to fill in gaps in the existing framework. Now, as I said, the negotiations have been going on since the year 2000. The current impasse and the key outstanding issue on which there are concerns expressed by different groupings is the question of addressing acts committed in the course of an armed conflict, particularly in situations of foreign occupation. On the other hand, there are proposals on dealing with acts of military forces of states in peacetime, and so on. So these are the concerns that are being addressed now. Now, in order to address this range of concerns, the coordinator of the Bureau has presented what is called a compromise package in 2007, subsequently revised, in order to meet or address in some way these concerns that have been expressed, which has held up the conclusion of this convention. Without going too much into the technical details in the interest of time, let me say that the exclusion clause, the coordinator's proposal or the compromise package, and the negotiations are proceeding on the basis of this compromise proposal, on the understanding, of course, that all the proposals made are on the table and nothing is agreed in keeping with the UN practice until everything is agreed. But in order to facilitate early conclusion of the negotiations, all delegations have agreed to carry on the negotiations on the basis of this compromise proposal presented by the coordinator and the Bureau of the ad hoc committee. The compromise proposal is essentially an exclusion clause, what is called a choice of law provision. It basically recognizes that the comprehensive convention will not exist in a vacuum. Once adopted, it will operate alongside other legal regimes. And there are special legal regimes. For instance, situations of armed conflict, activities of armed forces in a situation of armed conflict would be governed by IHL as the lex specialis. And therefore, the convention would not impinge on the applicable legal regime. Of course, at the end of the day, it's a matter for the courts to decide what is the applicable legal regime. So there is a carve-out pointing to the applicable law that would apply in situations of armed conflict. Similarly, with regard to activities of military forces of a state in non-conflict situations or peacetime, it points to the applicability of general principles of international law on state responsibility. So basically, it is a carve-out of legal regimes. Rather than excluding acts, it carves out applicable legal regimes and points to the applicable law in a given situation. And as I said, recognizing that a convention cannot operate in a vacuum. Along with the convention, there will be other legal regimes. It's a matter for the domestic courts of each state to decide in this situation, in these particular circumstances, what is the applicable law? Is it the convention? Is it international humanitarian law as lex specialis, human rights law, and so on? So that is the basic approach and thrust of this compromise proposal. It also makes it very clear that nothing in the convention would impinge on international humanitarian law. It's designed to preserve the integrity of IHL in those particular situations in order to allay concerns that the convention could create an additional layer of complexity with regard to the application of IHL. In order to allay those concerns, the compromise proposal is very, very clear that nothing in the convention would criminalize any act which is not prohibited under IHL. The current position is that the ad hoc committee last met, it did not meet this year, it last met in April 2013. One of the achievements of that session was that the committee was able to produce a consolidated text of a negotiation which had been going on since the year 2000. So many proposals were contained in different reports of the committee. But for the first time, the committee was able to present a consolidated text, also pointing to the areas of divergence in separate annexes, but it is available as one document. And given the turnover of delegations in the UN over a period of 10 years, now there's a ready reference point. When negotiations resume, it will resume on the 24th of October. Delegations will have a ready reference as to where we stand on the CCIT negotiations. Along with that, there is also, in my chairman's summaries in the report, I have also set out elements of a possible resolution that could accompany the adoption of the convention. And that's a well-known time-tested technique of the United Nations to address some of the concerns that perhaps it may not be possible to address in the convention itself in the accompanying resolution. And in addition to those provisions I mentioned about training camps, installations, and so on, the principles of state responsibility to be reiterated in the resolution in order to address some of the views, concerns expressed on the question of state